Welcome to Team Tigio Court TV, where we upload videos every single day. So make sure you subscribe to our channel, like our videos, and share our videos.
Differing on the service time.
Okay.
And we're also, did you get a word back on the probation violation?
We're gonna just, no, but we're gonna go forward. Cause we got everyone here. Hey, Ms. Rivers, are you good to go?
Yes, I'm ready.
Great. All right, let's get on the record in positions 4 and 5 from this morning's calendar. 25 SC 002135 and 2139. Both involve Mr. Fulk, who is standing up at the podium with his lawyer, Ms. Cabrera. We have Ms. Davis for the state. Good. It's now afternoon. Afternoon, Mr. Fulk. How you doing?
I'm all right. How about yourself?
I'm okay. Mr. Fulk, Ms. Cabrera tells me that you're prepared to enter pleas in your two cases and to also handle this revocation piece that's out there. The revocation relates to an older case you have with a different judge, and the basis of that revocation is a recent DUI you picked up. Do you understand that?
Yes, sir.
Okay. What we're going to do is work through the plea process. You're going to answer questions from Ms. Davis. I'll hear her recommendation. I'll hear your lawyer's recommendation. And then I'll tell you the sentence that I'm going to impose. If it is more severe than what Ms. Cabrera asked for, so let's say she says 5 and I say 6, that's a bigger number, you'll have the ability to withdraw your plea if you want to. But if the sentence I give you is effectively the same thing as what your lawyer's asking for, then you're obligated to go forward, okay?
Yes, sir.
All right. And you understand that regardless of what we do here today, if I say I am going to do the plea and I say more than what Ms. Cabrera asked for and you say I want to back out or I do less, there's this warrant for you. So you have to go into custody either way.
Yes, sir.
Okay. I didn't want you to think that I'm locking you up because you say no thank you to my, it has nothing to do with me. It has to do with this warrant that unfortunately for you is active and the deputies can't let you leave with an active warrant.
Yes, sir.
And the warrant is just for that probation violation. The new Cobb County DUI was a violation of that probation with the other judge. Okay?
Yes, sir.
All right. Ms. Davis is going to put you under oath, ask you a bunch of questions. Let me know if you have any questions of your own. Will you do that?
Yes, sir.
All right. Let's go.
Please raise your right hand. Do you swear or affirm the testimony you shall give in this matter before the court shall be the whole truth and nothing but the truth?
Yes, ma'am.
Okay, you can put your hand down. Please state your true, correct, and legal name.
Jaquan Anthony Folk.
Can you spell your first name for the record?
Jaquan.
Are you at this time taking or under the influence of any alcohol, drugs, or medication?
No, ma'am.
Is there any medication that you normally take that you have not taken today?
No, ma'am.
How old are you and how far have you gone in school?
I'm 37 and I have associates in horticulture.
Okay. And where did you attend?
University of Georgia.
Nice. Are you able to read, write, and understand the English language?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that you're charged with the following offenses in indictment 25 SC 002135, aggravated assault, possession of a firearm during the commission of a felony, theft by receiving, theft of services, obstruction of a law enforcement officer, tampering with evidence, reckless conduct, and possession of a firearm by a felon. And Judge, there are 2 counts in this case. We will be moving to null pros the last count.
Of the firearm by felon?
Yes, Judge.
Thank you.
Do you understand you're charged with that in that indictment?
Yes, ma'am.
Okay. And you're also charged in indictment 25 SC 002139, aggravated assault, terroristic threats, possession of a firearm during the commission of a felony, simple battery, cruelty to children in the 3rd degree. There are 2 counts, and possession of a firearm by a felon. There are also 2 counts in this, Judge, and we'll be moving to null pros the last count.
Okay.
You understand that?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your lawyer, Attorney Cabrera Demore?
Yes, ma'am.
Have you discussed all the facts and circumstances known to you regarding the charges in your indictments, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with her services?
Can you repeat that?
Are you satisfied with her services?
Yes, ma'am.
Attorney Cabrera Demore, do you waive formal reading of the indictments and any and all defects therein for the purposes of this plea?
So waived.
Mr. Folk, do you remember having been arrested on both of these cases?
Yes.
Your Honor, the state is unaware of any outstanding warrants related to both of these matters. Attorney, are you aware of any outstanding warrants related to this case?
I'm
Or
not.
both cases?
I'm not.
Okay. Mr. Folk, has your attorney advised you of the minimum and maximum sentence for each charge to which you are pleading to today?
Yes, ma'am.
Okay, and I'm going to go over those. So in indictment 25 SC 002135, aggravated assault, minimum of 1 year, max of 20 years. Possession of a firearm during the commission of a felony, 5 years consecutive. Theft by receiving, minimum 1 year, max 10 years. Theft of services, 12 months. Obstruction of a law enforcement officer, 12 months. Tampering with evidence, 1 year to 3 years. Reckless conduct, 12 months. Possession of a firearm by a felon. And this is your second offense, so it would be 5 years to 10 years. And in indictment 25 SC 002139, aggravated assault again, 1 year to 20 years. Terroristic threats, 1 year to 5 years. Possession of a firearm during a felony, 5 years consecutive. Simple battery, 12 months. Cruelty to children, 12 months. Cruelty to children, 12 months. And possession of a firearm by a felon. Again, this is the second time, so it would be 5 years. Minimum, max 10 years. You understand that?
Yes, ma'am.
Okay. Do you understand that today you are entering a non-negotiated plea or a blind plea, and the state will still make a recommendation to the court?
Yes, ma'am.
Do you understand the court can impose any sentence authorized by law, including a higher sentence than recommended by the state, up to the maximum sentence on each charge?
Yes, ma'am.
Do you understand if you enter a non-negotiated plea today, you do have the right to withdraw that sentence if you're not in agreement?
Yes, ma'am.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as other jurisdictions, including in federal courts?
Yes, ma'am.
Do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would? And that is true regardless of any advice by your attorney or anyone else.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you'd be guilty of a felony which may carry a sentence from 1 to 15 years in prison?
Yes, ma'am.
Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes, ma'am.
For example, your guilty plea may affect the right to vote, to hold public office, to serve on a jury, to obtain a passport, to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights? And I'm going to go over 9, then ask you, do you understand, okay?
Yes.
The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. Do you understand that?
Yes, I do.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you have only 4 years from today for the felony charges and 12 months from today for the misdemeanor charges to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Has anyone forced you, threatened you, or promised you anything to get you to enter this guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, ma'am.
Is your guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes, ma'am.
Okay, Your Honor, the state believes at trial the evidence would show in 25 SC 002135 that on July 11, 2023, officers of the Roswell Police Department responded to a complaint by the victim identified as Gustavo Cadenas, who reported through a translator, Ms. Perez, that the victim was sent to 57 Old Holcomb Bridge Road in Roswell, Georgia, in Fulton County for a taxi request. The victim and translator worked for Morelia Taxi. The victim picked up the defendant, later identified as Jaquan Folk, but he made the request in a different name from the La Quinta Inn. The victim transported the defendant to Crystals, but he did not have money to pay for it, and the victim agreed to add that amount, which was approximately $9, to his taxi bill. The victim brought the defendant back to La Quinta Inn, where the defendant took the food inside and came back out to be taken to the Citgo gas station. The defendant got back in the vehicle and was driven to the area of North River Tavern, which was the final stop. The victim informed the defendant of the total amount for the services, which was $27 for taxi services and $9 for food, for a total of about $36. The defendant refused to pay. The defendant brandished a firearm and the victim left. The victim reported the incident to police and they were able to track down the defendant to the La Quinta Inn. Reviewing the surveillance footage, the defendant attempted to flee on foot but was ultimately tracked down. Officers also observed on security footage the defendant discarding a loaded weapon in the trash can at the hotel lobby near the elevators. The defendant was Mirandized and agreed to speak with police. He stated that he asked the driver for change for a $20 and $5 and was giving 4 $1 bills. So when the driver told him he owed $39, he thought he had already paid for what was lent to him. He admitted to brandishing the gun and stated that he thought his life was in danger. He admitted to throwing away the gun in the trash, and he knew the gun was stolen. He also thought the police were after him because he's a convicted felon and can't have a gun. We have not made any contact with Gustavo Cadenas. We have not spoken with him.
Okay. It wasn't a situation where, not to minimize this at all, but Mr. Folk didn't discharge the firearm or strike anyone with it. It was a, hey, back off, I'm not paying you, and he took off.
Correct.
Okay.
Correct. In indictment 25 SC 002139, we believe the evidence will show that on June 17, 2003, officers were dispatched.
2023?
3.
Yeah.
I'm sorry.
That's okay.
2003, right?
Yeah.
Okay, 2023.
really old.
Big, huge difference. Officers were dispatched to 1005 Summit Springs Drive in Sandy Springs, Georgia, in Fulton County. Upon their arrival, they spoke with one of, I believe, 2 victims, Mr. Boris Hall. They also spoke with Zambernique Curry and a Navario Cullen, who was just a witness. They advised that the defendant, identified as Jaquan Folk, was in the apartment and he had a handgun, and that he pointed the handgun at Miss Curry, Zambernique, and told her that he was going to kill her. Officers also were advised that there was a verbal altercation in the parking lot near the apartment, and that Hall and Cullen. Oh, and during that altercation, one of the victims suffered a seizure attack. And during this attack, Mr. Folk had slapped the victim, Mr. Boris Hall, in the face. And so when officers arrived, they tried to make contact with Mr. Folk, but he did not answer the door when they approached apartment 1005. Based on Mr. Folk's cases and a global resolution, the state is recommending 15 years to serve 5 of those years in custody. We're recommending the balance be on probation, that he completed, well, he doesn't need to complete his GED as an associate's, that he forfeit all firearms in both cases, that he have no contact with the victims and stay away from both incident locations. And I will provide that information to Ms. Nelson. The way that we are arriving at the 5 years is 10 years on both aggravated assaults, 5 of that to be served in custody, and then to suspend the 5 years consecutive for the possession of a firearm during the commission of a felony in both cases if the defendant has completed all the terms and conditions of probation. For all of the misdemeanors, we're recommending just a year to serve, so there's no probation associated with those. And we are also, in lieu of this global resolution, because we also anticipate wrapping up the probation revocation for him to be sentenced to a drug treatment program in custody. In light of all that, we are going to withdraw our recidivist notice that was filed.
Okay.
And nothing further from the state.
Got it. Thank you for that. I was just checking how long he was in on that. Ms. Gordon, hello again.
Yes, Your Honor.
Can you share criminal history information about Mr. Folk, please?
Yes, Your Honor. The defendant has 22 arrest cycles beginning in 2005. The last arrest was July 26 of 2025 from Smyrna, Georgia. Driving while license suspended or revoked. That charge appears to be open. 4 prior felony convictions outside the 10-year period. A 2017 felony conviction from Fulton County, possession of a firearm by a convicted felon, and a March 12, 2025 felony conviction, Fulton County, theft by receiving stolen property, fleeing and attempting to elude. 5 years probation on case 23 SC 190121. Nothing further to add, Your Honor.
Thank you, ma'am. Ms. Cabrera.
Yes, Your Honor. So you know that he went to school, you know, he's 37. He does have 7 children, 6 girls, 1 boy. He was the one that asked about drug treatment while in custody. And so I think that should be noted. Most often you're asking for drug treatment for the purposes of not being in custody, to be allowed to be someplace else. But he's asking for the ability to receive treatment while he is in custody. He is supported today. They've had an opportunity to speak with one another. My recommendation for the court actually looks a lot like what the state is asking. What the only difference is that I'm asking for the service of 3 years and not 5 years. And that once we reach the part for the probation violation, that he'd be allowed to complete the RSAT program while he's in custody.
Okay, couple questions. One, who is here supporting him?
My mother.
Okay, mom is here. Thank you, mom, for being here. 2, it would be treatment for what? What is it that you think you struggle with?
Marijuana, cocaine, and Percocets.
Okay. How long has that been a struggle? Oh,
I'm sorry, he also was receiving treatment for hypertension and he battles depression.
okay, got it. Do you take medication for either the hypertension or the depression?
Not for depression. I have never been diagnosed, but hypertension, my mom, she gave me like holistic. I take beets and turmeric and, you know.
Okay, but not, which is great, but there's not a doctor who's saying, and also take medicine X.
I was on, I'm trying to remember the name, but amlodipine, but it messes with my manhood, so I stopped taking it, and my mom could get.
You might have fewer kids if you start taking that. You got a lot of kids. How do you support 7 kids?
I work.
What do you do?
Currently at McDonald's, I work, and I do other like app jobs, like in Insta work or survey merchandise.
Yeah.
And people ready job stack.
Okay. The horticulture degree, I don't see a lot of those. What were you hoping to do with that?
I was hoping to work for like parks and recreations. But when I was released, I got into a program called EMAN, and I became a apprentice in carpentry and plumbing.
Okay.
So
you got those skills too?
Yes, sir.
Got it.
But horticulture, I wanted to like trim trees and, you know, bushes, learn, you know, like lawn care, stuff like that.
Okay. So I want to make sure that whatever sentences flow out of this track, I can't sentence Mr. Folk to custodial time in either of the two cases we just talked about and have him go to RSAT. Just want to make, because you recommended 5, you recommended 3, and neither of those would work if there's going to be a revocation that will result in getting close to 3 years, because there's the wait to get into RSAT, and then RSAT is 18 to 24 months. But I just wanted to make sure, as we had been having an informal discussion about it, that both sides understood that the sentencing for the 2 cases that we're primarily here on is probably going to look like, call them LaGrua sentences, where the prison time is on the back end, and that can go away by way of a sentence modification if things go well with RSAT, and then there is some continued time on probation after that, if that makes sense.
I know exactly what they look like.
Yeah, probation doesn't like them, and they're hard to process when they're structured that way, but that's what we do. Mr. Folk's mom is raising her hand. I don't know if you want to check with her.
I can go over there real quick. Would you mind finding out the RSAT?
If you send it to me, I can do that. Is it 1,000,000 pages?
No, 6.
Okay.
That's considered 1,000,000.
Can you get? No, I think I can. Mostly it works. Sometimes this printer doesn't work, but if it does, happy to do it.
She just wanted to share her recollection of when his drug issues took place. It's 2006.
Okay, so this is not new, and it's persistent, and it's something for which help would be a good thing. So, Mr. Folk, I find there's a factual basis for both your pleas. It sounds like you are quick to get angry, and you, at least back in 23, and I'll acknowledge this is 2 years ago, hopefully things have gotten better for you, but because you carry a gun, which is illegal for you because you're a felon, sometimes the way you try to resolve your situation is by flashing the gun, playing with the gun, pointing the gun. None of that's okay. Your gun could accidentally go off. You could get even more angry and discharge the gun, or you flash a gun and another guy doesn't flash it. He pulls it out and puts 2 in your head. And that's not a good outcome for the 7 kids you've got. In this day and age, you pull a gun out in a crowded space, you shouldn't think that you're the only one with a gun and the one who's going to control the situation. It's one of the least safe things you could do, other than drinking and driving, which sounds like you did in July of this year. I don't know how to impress upon you the need to leave the guns behind. And sometimes young men in front of me will say, yeah, but you don't understand where I live or the people I hang out with. And I do understand. It's just not an option that you have, especially when you couple it with, I don't know if it's the people in your life or what was going on, but you were too quick to be saying, and here's how we're going to resolve this. And then you show people your gun or you put it in your hand. And that's just going to end in a real bad way for someone you care about. And it could be you, the one that you care about. Heaven forbid, do you spend time with your kids?
Yes, sir.
Heaven forbid, you get, your temper goes and you show someone your gun and they shoot at you and they're bad aim. And then you've got a 4-year-old who's bleeding out in a car seat in your car. We started a trial today in this courthouse of the little girl who got shot near that Wendy's because these tough guys were showing their guns and they fired some and it killed a little girl. I don't think that guy meant to shoot the little girl. I had no beef with the little girl, but you mix guns with anger and hot tempers and maybe a little immaturity and these real tragic things happen. I don't see you as a killer. I don't. But when you're messing around like that, then in a split second, all of a sudden you got a murder charge hanging on you. Like this young man who's going to trial in this building today. So, long sermon, but when I learned you had 7 kids, my heart sank a little bit because these cases make you sound a little reckless. And that recklessness could leave 7 kids without a dad, or a dad that they get to know by looking at him through plexiglass in the Department of Corrections, because you got 30 years to serve, which is not what's happening today. I'm all about second chances. And when you get through RSAT, you're still going to be young. Your kids are going to still want to see you, and you may be in a position to be there for them in a more consistent way. So I find there's a factual basis for both your pleas, and that your pleas are knowing, meaning you've understood what we talked about, and voluntary, no one forced you to enter the pleas. Do you agree with that?
Yes, sir.
Okay. I'm sentencing you pursuant to the Probation Options Management Act. We talked about horticulture. Ms. Cabrera, can someone in my office sign both indictments for you?
Yes.
Ms. Davis?
Yes, Your Honor.
And Mr. Folk, is it okay if we electronically sign your name to the indictments?
Yes.
Just indicating you're pleading guilty?
Yes, sir.
So we'll do that. And what I'm going to do, look at these counts here. Count 1, I'm sentencing you to 15 years. No, I guess it has to be 10 years. I'm going to talk about how it's structured in a minute. So count 1 is 10 years. Count 2 has to be 5 years, and it has to run consecutive to count 1. So that is a total of 15 years. It's hard to see here. And I guess I should be clear. This is in indictment 25 SC 002135. So the first of the 2 indictments. Count 1 is 10 years. Count 2 is 5 consecutive. 3 is 5 years concurrent with count 1. 4 is 5 years concurrent with count 1. 5 is a misdemeanor, so that's 12 months concurrent with count 1. 6 is 3 years concurrent with count 1. 7 is 12 months concurrent with count 1. And 8 is 5 years concurrent with count 1. So that all adds up to 15. And the way it's structured is that the first 10 years are on probation. The final 5 years are in custody. But if you get through RSAT and you get a few years of probation under your belt with no arrests or anything like that, then I will modify those 5 years to be suspended. So there's this thing hanging over your head, but that's for good purpose. Because if you get kicked out of RSAT, or you get out and you go back to the way things have been, then all that falls down on you, and it falls down pretty hard. And that would be bad, but that's the consequence of you not turning the corner. It sounds like you want to turn. In your other case, 25 SC 002139, and how did you know Ms. Curry and Mr. Hall?
Mr. Hall was a roommate. His girlfriend let me and my former girlfriend rent a room out of their house.
Got it.
And
So Mr. Hall was a roommate.
Yeah, his girlfriend owned the apartment.
And that's Miss Curry?
No.
Miss Curry's your girlfriend?
No.
Who's Miss Curry?
She was, I guess, like his play aunt. And
that doesn't mean a girlfriend. That means he calls her auntie, but they're not really related.
Yeah, she stays around the neighborhood.
Okay.
Like that.
Got it. So the main guy you knew was Mr. Hall.
Yes, sir.
But his play aunt was around.
Yes, sir.
Okay. All right. Well, getting to that case, which is the case ending in 2139, your sentence is to count 1, which is aggravated assault. It's going to sound similar because it's meant to be like the other case. Is 10 years. Count 2, 5 years. Those will run concurrently with each other. Count 3 is 5 years. It has to run consecutive to count 1. 4, 5, and 6 are all misdemeanors. They're 12 months concurrent with count 1. And then 7 is 5 years concurrent with count 1, and the state's dismissed count 8. And that'll be structured the same way, where the first 10 years are on probation, and then those final 5 years are 5 years to serve. But hopefully we never get to that. Special condition of probation in both cases is that you forfeit the guns. All that means is you can't now go back to law enforcement and say, hey, those guns that you've got, or gun, however many they seized. I know they got that one from the garbage can. It sounds like you weren't arrested initially for the situation with Mr. Hall. You can't go get that gun. That can be destroyed and it's not yours anymore. And then no contact with any of those folks. And it sounds like that's easy with the cab driver. I don't know if you and Mr. Hall still talk, but don't anymore. We'll leave it at that. Now, what I'd like to do, assuming Ms. Cabrera, you're waiving any due process notice rights that you and Mr. Folk have, is handle the revocation in the case 23 SC 190121. That's the case where there's just shy of 5 years left.
Right.
You ready to go forward with that?
We are, Your Honor.
Okay. So, Mr. Folk, as a result of, in that case, the allegation is your new DUI. And so all you're admitting to here is, yep, I got arrested for a DUI and driving with suspended license. Officer Evans?
And there were some special conditions
He hadn't done substance abuse evaluation.
and the defensive driving class.
Okay.
I don't have a record of it.
Okay, but that all fits nicely with the, we're going to get you some treatment. But there's some technical violations, and then you got arrested for some things while on probation in this other case. And as a result of those violations, I am going to revoke 4 months of your probation in that case, and then add a new special condition that you enter into and complete the DCS RSAT program, which is a custodial treatment program. So you don't get to walk away. The doors are locked on the outside, not on the inside. But that is drug treatment. It will include mental health treatment. So an expert will meet with you, and if medication makes sense with the depression, then that'll be prescribed, see if that helps. So it's holistic. It's not just, hey, you drink or smoke too much, but it's also maybe you're working through some mental health challenges, and let's treat those as well. Because sometimes people self-medicate, and really, if you took the doctor's pill, you wouldn't need the street pill, which is the illegal one and is the one that gets you in trouble. You'll also need to participate in the aftercare, and that aftercare would be a special condition of your probation in your 2 new cases, meaning these gun cases, the old facts, but your new pleas. Okay? Officer Evans, I'm going to try to print that paperwork out right now. Is there anything more you need me to say to handle the revocation piece?
Your Honor, I've never heard it to where we would revoke 4 months and then add the RSAT on the aftercare. So is that something?
So it's what Ms. Simpson said we should do the last time I did this. So kind of recently, it was revoke enough time that the waiting period can occur, because we were told the wait to get into RSAT for men was like 2.5 months. And so what Ms. Simpson said was revoke more than that. So there's a reason to hold him. So he'll be in custody. He's been revoked. And then the RSAT isn't actually part of the revoked time. It's the special condition. And so it's revoke into RSAT, but the revocation piece is just long enough to cover the waiting period. Now, you're the professional. I'm not in this space. And so if you want to check with someone, or you know that what I just said is the wrong way to do it, then we could revoke more time. But what I was told was revoke more time than is needed to get off the wait list, but have as a special condition, enter into and complete RSAT and aftercare. And of course, he'll get credit for his probation while he's in there, but it's just the special condition.
So the wait time that is provided, the 2.5 months, is an estimate, but it's not guaranteed. And I've been told something else in regards to that. So I could have.
Please, no, do check, because I want this to be the right sentence. And if I need to revoke 2 years, but the 2 years includes the RSAT, we can do that. It's gonna have the same good outcome for Mr. Folk. Though I was told, don't do the big number because you never know, he could get through RSAT sooner, or it may take a little longer depending on how he's doing.
You get the time served upon completion of the RSAT program.
I didn't know you could do that with revocations, but okay, well, why don't you check and see what the expert says?
Thank you.
You bet. We're just trying to get it right.
Sit in that chair over there. Just have a seat.
Estimate. However, it has been even longer than 4 months. That's why before we were doing the revoke 1 year, 2 years, commuted time served, audit treated to however, she said that, it would be better for us to do 6 months.
Okay.
You know, just to kind of make sure that he can get in.
But then it's reduced to time served upon entry into, and then the actual time in RSAT isn't, so I don't revoke 3 years and part of that is RSAT. Revoke enough time that the wait list can run through and he can get in. Okay, all right, got it. And there's your magic list. All right, so back on the record, what we'll do, Mr. Folk, in your 23 SC 190121 is revoke 6 months. That has the added benefit. It won't be the full 6 months. You'll have time. You have to resolve your situation in, is it Gwinnett or Cobb? Cobb. You can't get into RSAT with open charges because they don't let you leave while you're there. I got to go to court in Cobb. Well, then you can't do RSAT. But that's a few months you can take care of the Cobb situation. So I'll revoke 6 months, but that 6 months will be reduced to however long the wait list is. If you get off in 3 months, then it's 3 months. If you get off in 4, it's 4. Then you'll be in the RSAT program, and you'll need to complete that and any aftercare. Aftercare is on the outside, so you'll be released, but you'll still get counseling sessions, things like that. That's all part of your probation. And that aftercare will be part of your probation in what I'm calling your 2 gun cases as well. Yes, and if you successfully complete RSAT, all that other stuff, your lawyer is going to be reaching out to me saying, could we amend the 2 gun cases to take away the 5 years to serve that is 10 years down the road? Because that's not what you need when you turn 47 to then spend 5 years in prison. But you control that. It's how things go. Anything else, Ms. Cabrera, on behalf of Mr. Folk?
No, Your Honor, this actually is pretty damn good.
Okay. Do you need anything else, Officer Evans?
You have that, PV case number?
I think it's kind of hard to read. Does it end in a PV?
No, it starts with 25 PV. It would be under related cases in the.
Oh, let's look in Odyssey. Okay. Yeah. That I can get you. And Mr. Folk, if you have anything with you that you want to leave with your mom.
I already did.
Okay, like you don't mind that jacket? I don't know that you'll see that jacket again.
It might be cold and down intake, so.
Okay, they let you wear it in intake?
Yes.
Okay, then there you go. It's not showing up there. Let's look at the new case. I'm not finding it.
Custody, so there wouldn't be.
There wouldn't be a PV number yet. Okay, good, because it wasn't showing up. All right, Deputy Gordon, thank you.
Thank you. Did you want me to wait before I come back here?
Yes.
And Deputy Gordon, you don't need the final dispositions because he's going into custody on the warrant. Good, because those are going to take a while. I want to give Ms. Nelson the time she needs for those. Okay, great.
For the RFS program, once you finish RFS program, you'll be released and you'll have 6 months after.
Okay.
Mhm, you're welcome. So it's far less than we thought it was.
Okay.
And Judge, while we're still here, I believe I said one of the victims was Boris Hall. Did I say Ms. Curry's full name for the record?
You did. It was Zebra